Hey folks, Clark Proffitt with HPS Law Group here. Today I want to talk about provisional applications and how provisional patent applications are different from non-provisional patent applications. So the way a non-provisional patent application, which is your normal patent application, works is it gets filed, it goes into the PTO, it gets in line, it's going to get examined by an examiner once they get around to it. They're going to look at it, determine whether it's useful, novel, non-obvious. If it fits all those criteria, it's going to be allowed and it's going to issue as your patent. So that's your non-provisional. And that's your normal patent application. The provisional is a little bit different. The provisional goes into a vault basically. No one's going to look at it. It's going to sit there and just give you a foot in the door for when, and only ends up getting in line to get examined and issued as a patent if you file the non-provisional claiming priority back to your original provisional. So the way to think about these a little bit is like your non-provisional is a living organism that is live born. Sharks, people, we are born alive. So it takes a little bit more effort in order to have that live birth. It costs a little bit more for your non-provisional application, but a living, breathing thing comes out and is able to move and act in the world. That's your non-provisional. Your provisional application is more like something that gets laid as an egg. And so for a period of time, it's going to stay in the egg, it's going to continue incubating, and then eventually it's going to hatch out of that egg and be able to move around and act in the world. And that turns into your actual patent application. So you're going to file your provisional patent application, takes your idea, gets it out, puts it in the egg, gets it starting to cook and ready to go. You've got 12 months then for that idea to incubate before you have to file the non-provisional application if you want to. And then all of those same efforts have to go into filing your non-provisional so that it works. Provisionals are much easier to file. There are no format specifications or anything else that you have to do, so you can just take a series of photos, write it up, and file that thing. It's much cheaper. If you're a micro entity, it can only be $75 to file that. It's still kind of a hassle on the website to do, but it's doable, right? And so it's not that much effort. It's like laying an egg as opposed to giving live birth. So that's kind of how I think about it, is you want your living patent application to get out there and get started, to be examined and issue as a patent. If you want to, you have the option to lay that egg and give you the 12 months to keep it cooking before you spend all the effort to get it moving through the formal patent application process. Thanks. Oh, call us at HPS Law Group if you have any questions. We're always available, and we have weird metaphors to explain things like that.